We know the window was not the point of entry or exit. Anita's blood was in the cut on the screen and nowhere else on that screen. Only in the cut from the evidence that you heard, which means that it was made with the knife that was used to stab Anita.
This is 2025. This isn't Perry Mason in 1950. And it's a media circus because they can put her in that chair, and these people helped them do it. And it's garbage.
We're on a verdict watch this morning in the toxic roommate murder trial. The prosecution saying that Nichole Rice is the only person with access and motive to kill Anita Knutson. Rice's defense team, though, says that Nichole is just a North Dakota mom who's been targeted by a TV show. And accused killer Luigi Mangione is requesting a laptop. That's trending in true crime. Does he need it, though, to have a fair trial? We'll discuss. Also coming up this hour, we're spotlighting the latest wins and losses in Karen Read's murder retrial, the rulings and which side now has the advantage. Plus, Bryan Kohberger's family could be called to the stand in the Idaho student murders case. We'll talk about how the latest court filings could be tipping the scales of justice when this case goes to trial. It's all coming up next for you, plus much more right here on Opening Statements. Good Wednesday morning to you and welcome to Opening Statements. I'm Julie Grant. I say the show's like coffee in court because it's morning time and we get all warmed up together for the big day ahead on Court TV Live. So go ahead right now, grab that cup of coffee or tea or hot water with lemon, whatever you drink in the morning. It's time for my opening statement. How would you feel if you're Bryan Kohberger's family? You know, it's a question I probably haven't thought about enough. His family has been victimized too. They didn't ask to become part of this case. I'm sure they are appalled and sickened by the allegations that have been brought against their loved one. Bryan Kohberger is a 30-year-old man. He is responsible for his own actions and his own choices. If he did those 4 murders like police say he did, then he and only he is responsible, not his family. His parents and his siblings should be treated with dignity and with respect, and they shouldn't be shunned by the public or treated like suspects at trial because they're not. They're innocent people, just like those 4 beautiful, innocent students who were killed. Madison Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin are the case victims. They and their family members are most certainly the main concern for everyone who wants to see justice served. But my point this morning is, in homicide cases, we often don't view the defendant's family as being victimized, although they have been, just in a different way. They've been victimized by the actions of their loved one, and their lives have been changed too forever. This is just something we can think about in the case of the Idaho 4 student murders. And in every case, we should remember that there are victims on both sides. That's my opening statement. Let me know if you like it. And by the way, we have much more discussing to do of the Bryan Kohberger case. It's coming up for you later on this hour. But right now, it's time for your daily docket.
Who's in the house? Who else is in here?
My stepson is in here.
How many other people?
Help him out.
Listen,
That's it. I have 2 cats.
Everybody's out?
Yes.
But your stepson's still inside?
Yeah, he's right here.
Okay,
yes.
come out. Come down the road. Come on.
In Connecticut, we've got the woman accused of keeping her adult stepson held captive in the family's home for decades in court today. That's right. Kimberly Sullivan is going to be arraigned at 10 a.m. Eastern time. So we're watching that. And in Michigan, jury selection continues in the battered and burned murder trial for Linda Sturmer. The facts are stunning in this case. And by the way, this is a retrial. Court's going to start up at 9 a.m. We'll take you live when it does. We've also got jury selection resuming in Massachusetts in the surgeon strangles wife murder trial. We're calling this one. This is the case of Dr. Ingolf Turk. This is one we've been reporting on for a long time. It's alleged to be a domestic violence case. Court's going to start up at 9 a.m. Eastern. We're watching that courtroom too. Right now, my friends, let's get you to our top story on the show this morning. Deliberations are resuming at 10 a.m. today in North Dakota. And you guessed it, the toxic roommate murder trial for Nichole Rice. That jury was out for over 4 hours on Tuesday. No verdict yet. Rice is accused of murdering her roommate, 18-year-old Anita Knutson, back in 2007. She was later charged 15 years after Anita was killed. Now, police cited several inconsistencies in her story that led to the charging about where she was when the murder happened. Her defense team, though, maintains that she is innocent and police should have been focusing on other suspects. Let's take a listen together to some of what the state and the defense said in closing arguments.
Only one conclusion to be drawn, and that is that in the early morning hours of June 3rd, 2007, Nichole Rice took this knife and plunged it into the chest of this girl and killed her.
Their case doesn't work. Their own lead investigator, Detective Asham, told you guys she didn't review the whole file. That's not bad police work. That's insane to bring charges when you haven't reviewed a file. They're trying to say this is a puzzle with many pieces. No, it's a murder case. And everybody in here deserves justice. Anita and Nichole, and this isn't how you get it.
So good closing arguments from both sides here. This is a tough one. You can see why this case went to trial, right? Not a slam dunk. So who's going to win? Who do you think? Hit us up on social media. Let us know. Right now, I want to bring in our legal eagles, our legal analyst guest this morning. It's Wednesday. We've got Casey Early and Franz Borghardt with us. Good morning to you both. I want to get your thoughts on whose case you think this is and why. Ladies first, please. Casey, would you start us off?
Yeah, I give it to the defense because the state has a host of issues, starting with time. All of the years that went by, you have the witnesses' memories, you have to constantly refresh. But I think the main problem is that Nichole allegedly made this confession while she was drunk back in 2008. So just a year after this alleged incident. So why didn't they focus harder on her at that time, complete their investigation and bring charges at that point? And what happened between her confession and 17 years later when she's brought to trial? They always say that a drunken person speaks a sober mind. So if that is the case, and in addition to her inconsistent statements, you would think that they would have had enough. But I think that the battle within the deliberations is the fact that they don't have more. There's a lack of direct evidence, the witness recollection, the motive. It appears to be a toxic relationship or issue over the alarm clock. Is that enough? I don't think that that is enough evidence for a conviction in this case, and either there may be a hung jury or not guilty.
Yeah, Casey, great points. Thank you for that. Franz Borghardt, what do you think?
You know, I always ask juries in voir dire, would you ever confess to doing something you didn't do? And under what circumstances do you think that that could happen? And occasionally I get, well, if I was really drunk, I might admit to, killing Jimmy Hoffa. It doesn't mean I killed Jimmy Hoffa. So, I'm on board. It was always a circumstantial evidence case. It was always kind of a case. And yes, normally, 9 times out of 10, a good old-fashioned confession to a guy you used to be in a situation with, that's his terms, not mine, situation, relationship, whatever, would be enough to say that's a good confession. I think it's kind of thin ice on this one. So I admire prosecutors bringing tough cases when they believe that the person sitting in the chair is the one who committed murder. But I tend to agree that there might be one or more jurors on this one that hold out and say, yeah, I don't buy it. I'm predicting hung jury. I'm not predicting outright acquittal. I'm predicting hung jury.
Franz, I'm with you on that. Thank you for those points. Let's talk about the guy that the defense is pointing the finger at, right? They raised an alternate suspect, and you both seem to think the defense is doing a little better than the state is on this one. Let's hear from their expert witness. Here we go.
In your expert opinion, what is Devin Hall's connection to this case? I believe he's the most likely suspect, in my opinion. And if I were investigating this, I would tie down a lot of these loose ends that they've left open.
And you had testified earlier that this was not one of the 4 suspects that when the investigation was reopened with Cole Justice and they were assisting Sergeant Asham, he was not on the list.
He was not on the list, and I was dumbfounded as to why isn't the person that appears to me as the strongest suspect not even visited in this show.
Okay, Casey, did you like what the defense did, calling this retired FBI agent as their PI?
Of course, because he has no dog in the fight, right? And then he has this expert essence to him. And I always like to attack the investigation. That's one of my great lines that I like to use in closing arguments, especially when there's sloppy police work, that the investigator is only as good as the investigation. And if there was something missed for a serious charge, such as murder, and you failed to thoroughly look at the complete file, which the defense attorney utilized in his closing argument, attack the investigation, attack any other possible suspects, because there is your reasonable doubt. So if you do have holdout jurors, you're giving them multiple reasons why they're holding out, whether it's because they think someone else did it or there's not a direct evidence linking her, like they love DNA. So I love to think like a juror during the trial and then utilize my legal expertise during closing arguments to show that the state failed to prove beyond a reasonable doubt that my client committed this crime.
Casey, thank you for that. I have a clip I want to play now from, this is from Nichole Rice's aunt, who took the stand. And when it comes to what evidence was most convincing for the state, I think this is definitely up there. What she shared, her niece told her about her feelings toward her roommate, Anita. Let's watch.
What'd she say? She deserved to die. She was I have no more questions for Brenda.
So, Francis, a couple things could be possible here. Nichole Rice, we know, she's cloaked in the presumption of innocence legally, and she may not have done what she's being accused of. She might have despised her roommate. I think that's clear, but doesn't mean she killed her, or she could have killed her, and maybe the state just can't prove it. Tell me what you think of the aunt's statement about that animosity that Nichole Rice had. Does that tip the scales for you in leaning one way or the other?
I'll say this. Rice is not going to be convicted of being a nice person. I think we can all agree that at the end of the day, whether now or back then, she probably wasn't a great person. But being a bad person doesn't necessarily make you a murderer. And I'm going to say something that's not popular, that some people, when there's someone who dies that they don't get along with, they say stuff out loud that may be how they really feel. But it, again, doesn't necessarily make her a murderer. Now, that all being said, if I'm the state, like a drum, I'm pounding on the fact that, yeah, she deserved to die. You know why? Because you killed her. And that's why you were admitting to your aunt what you admitted. And look, there are going to be some jurors that can't conceive of one human being looking at another and saying, this person deserved to die. So that is a big issue for the defense. Now, isn't it enough to get past reasonable doubt? Is it enough to get past, was she just being euphemistic and saying, yeah, that person deserved to die? They were a bad person. I don't know. I still think hung jury is likely what we're going to see.
Yeah, I think that's a great prediction. And Franz, thank you for sharing that point. You're right. People do make comments, and sometimes a comment is just that. Okay, we'll get the clock up as soon as the jury is back. 10 a.m. Eastern time is when they've been called to report to continue their civic duty. Franz and Casey, I'm so glad you're here. Stand by kindly, please. We're going to hit a break. My Cordy friends at home, go refill your coffee. Coming up next, we're talking about Ghost Adventure star Aaron Goodwin and his wife, Victoria. She's behind bars and making her first court appearance as police say she started a murder for hire plot to kill her husband, and they say she was doing it with Grant Amato. We'll talk about it and the biggest takeaways from defendant Karen Reed's final pre-trial hearing as we're looking ahead to the retrial as prosecutors are trying to get justice for Boston police officer John O'Keefe.
mastermind behind a murder.
Monica Cementelli is accused of plotting to kill her husband.
Famed celebrity hairstylist Fabio Cementelli.
Prosecutors say she and her lover killed Fabio to collect a big life insurance policy.
The defense may say she's a bad woman, but she wouldn't be involved in a murder.
It's a whodunit Hollywood story, but will there be a twist that no one sees?
The celebrity stylist murder trial continues Tuesday, only on Court TV.
The maximum penalty possible for murder in the first degree and murder in the second degree as an act of terrorism is life without parole. The maximum penalty for murder in the second degree is 25 years to life.
Defendant Luigi Mangione is facing some serious charges as he's awaiting trial. He's accused of murdering United Healthcare CEO Bryan Kohberger. But the alleged assassin's latest request is what's trending in true crime. Luigi wants a laptop. In a court filing made public Monday, his attorneys are asking the court to provide him with one solely to look over the 15,000 pages of case evidence. Prosecutors, though, are concerned about possible witness tampering, according to the defense. Now, if this request is granted, the laptop would be unable to connect to the internet or any other form of entertainment. His attorneys say that he can only view the material during their meetings, but they're limited during his visiting hours. So we're wondering, should Luigi get the laptop? Let's bring in our power panel. Still with me, attorneys Franz Borghardt and Casey Early. I want to welcome in criminology expert Dr. Debbie Goodman. All right, Franz, would you kick off our discussion, please? Should Luigi get the laptop?
Well, I'll answer your question with the question. Do you want this trial sooner rather than later? If he has to go through all those documents, why not give him a secure laptop to where he can look at it? There can't be any argument that he doesn't have access to it. And candidly, if you don't give him the laptop, it's going to extend the shelf life of the case because as a defense attorney, I'll tell you, as someone who has to go to prison sometimes to show clients evidence, when you're talking about a document-intensive case, it takes a long time. And that really comes down to the question, do you want the trial sooner or do you want the trial later?
It's a good question you're raising, Franz. Okay, Dr. Debbie Goodman, what do you think? Should Luigi get the laptop?
I vote no, Julie, and here's why. Because jails and prisons have the provisions in place whereby individuals who are incarcerated, such as Luigi in the Metropolitan Detention Center in Brooklyn, New York, are able to communicate consistency and with continuity via regular mail with pen and pencil. They have makeshift libraries with books, and of course they are allowed to consult with their legal representatives. And so to grant Luigi this privilege, what about the other inmates? So I'm voting no.
I like it, Dr. Debbie. Thank you. Casey Early, what do you think? Should he get the laptop?
Luigi should get what every other inmate gets and not preferential treatment. So if there has been previous provisions made for other inmates to have a laptop temporarily, of course, limited, like you said, no internet access, no access to video games, solely to review 15,000 pages of documents, then absolutely he should get it. I've tried murder cases where unfortunately the jail did not provide the ability for me to give my client a laptop temporarily, or the jail provide a temporary laptop. So I had to sit there for hours and go over video surveillance and discovery just to make sure that my client assisted with his trial preparation. So I believe that he should get what every other inmate gets, because again, although the evidence to the public may seem overwhelming, he is still innocent until proven guilty and entitled to due process, which includes reviewing his discovery.
Casey, I love that point. Love that point. I'm sure there are plenty of other inmates asking for laptops like he is, but we're just hearing about his case for the reasons we all know. All right, we'll leave it there for now as we turn to another major case trending in true crime. It involves an alleged murder for hire plot and the estranged wife of Ghost Adventure star Aaron Goodwin.
Whoa, stop! I just heard a girl giggle, bro. Did you hear that? I swear to God. So again. Hang on, let me just see if there's any steps. Let's all see that. Dude, I heard a kid.
So his wife, Victoria Goodwin, appeared in court on Tuesday. She was arrested earlier this month on charges of conspiracy to commit murder. That's her. Investigators believe that she plotted to kill her husband, Aaron, last October with help from Grant Amato. Remember that defendant? Yeah, he's locked up in Florida for killing his family. Now, Victoria's day in court was brief. She waived her right to have a preliminary hearing. Take a look.
Your Honor, this was set for preliminary hearing. Originally, she had invoked her right to preliminary hearing within 15 days. She's going to waive that right today. This was called off at our request, and we're just asking for a status check during 2 weeks.
All right. That's correct, sir.
Yes, sir.
Ms. Goodwin, did you hear those representations put on the record by your attorney?
Yes.
And you're agreeing to continue this for 2 weeks for possible negotiations? All right, so that 2-week date will be?
April 8th at 8:30.
Thanks so much.
Thank you.
Aaron Goodwin broke his silence via Instagram a few days ago, writing this caption underneath, a smiley face emoji, thanking supporters through this trying time. He's since filed for divorce from Victoria, and prosecutors and Victoria's lawyers apparently are negotiating. They're talking about potentially resolving this by way of a plea agreement. That would be good for everybody. They're back in court on April the 8th. Okay, so let's talk about, do we think this is going to plead out, or might this case go to trial? And why is she talking to Grant Amato? That's what I want to know. Let's start with some of these messages here. According to the police report, Victoria sent Grant Amato messages in prison. Apparently she was fascinated by him and his case. You know, he murdered 3 people, mom, dad, and his brother. And she writes, am I a bad person because I chose to end his existence, not a divorce? Dr. Debbie Goodman, would you start off our conversation with this one, please, and help me understand why somebody, you know, who seems like she's living a normal, happy life. She's the wife to this star who I hear is a really nice guy too, Aaron Goodwin, and you know, and then she's fascinated with this killer. Why is that?
Right, Julie. It's called hybristophilia, where individuals become intrigued by, fascinated with killers. So that's part one. And then the part two for me regarding Victoria and this involvement is what I like to refer to as a criminologist as disposal theory. And so I think there are individuals among us who look at family members, close family members, potentially spouses, their children, extended family as disposable and see that, I believe, with Lori Daybell and her 2 children, Ty Lee and JJ. And we also saw it for the viewers who recall the Oklahoma case, wherein we had grandma, of all things, plot to kill her daughter-in-law and sadly the friend who was in the car as well. And we had a double homicide that grandma, mother-in-law orchestrated. And so it's just incredulous to me that individuals think they can participate in violent crimes and murder and think they're getting away with it.
Wow, fascinating insight. Dr. Debbie, thank you for that. And with respect to whether this is going to plead out, thank God Aaron Goodwin is alive and well and healthy, and this did not get so far as police say it could have gone. Casey, do you think this is a good case for a plea agreement?
This is definitely a good case for a plea agreement, especially looking at the evidence. I can never understand for the life of me, why do people plot or memorialize a crime via text message or email? And this is exactly what you have here. She can't explain that away. And then, of course, the person that she's communicating with, it's overwhelming evidence. And usually when I get a case like this, I go over the discovery with my client. I tell them the time and the risks that they're facing if they choose to go to trial, because, you know, that's their right. Or I show them the mitigation path about how they can resolve this via plea and know a time certain that they will possibly get out of prison, as opposed to leaving their freedom up to the hands of a judge who sat through a trial and heard all of the evidence against the person. So I do believe this case is going to resolve, and she needs to take her medicine because she put herself in this predicament.
Excellent points. Casey, thank you so much for that. We have to leave it there, but we'll continue watching this one. April 8th will be the next time she's back in court. Casey, speaking of court, I know we need to let you go there now. Thank you for your legal insight this morning. Franz and Dr. Debbie are coming with us, and please do so at home, too. When we return, we're talking about this.
We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Bryan Albert, Brian Higgins, and Colin Albert had.
We got the biggest takeaways from the final motions hearing ahead of Karen Read's retrial, and we're breaking it down with one of our friends who is inside the courtroom watching it all. Plus, Bryan Kohberger's family might be called to the witness stand in his upcoming murder trial. We'll talk about what may tip the scales of justice. Welcome back, and time for our spotlight this morning. And today we're focusing on the retrial of defendant Karen Read. With the conclusion of Tuesday's hearing, we're now heading toward jury selection. Next week, prosecutors looking to hold Read responsible for allegedly murdering her boyfriend, a 16-year veteran of the Boston Police Department, Officer John O'Keefe. Now, inside of that Massachusetts courtroom for the final motions hearing, the Commonwealth and the defense went toe-to-toe over some outstanding issues, including the defense team wanting to argue a third-party culprit defense. They're claiming that Colin Albert, Bryan Albert, and Brian Higgins are responsible for the death of Officer John O'Keefe. Take a listen to their argument.
The defense in this case has more evidence of third-party culprits than the defense did in Finney. We're not asking this court to allow into evidence hearsay, as was admissible in Finney. We're solely seeking to introduce the crux of a third-party culprit defense, which is evidence of motive, opportunity, and means, all of which Bryan Albert, Brian Higgins, and Colin Albert had.
There is no motive. There is no motive. To suggest that one person was pining, although the text messages don't show that, they both stopped corresponding with each other days before. To suggest that Mr. Albert is friends with Mr. Higgins and therefore he is bootstrapped into a conspiracy to kill with no evidence. There is no opportunity to murder John O'Keefe when all the evidence points to him dying on the front lawn from an alleged collision.
Now, the judge did not make a ruling yet. She decided to hold off on that and will issue a decision perhaps today, perhaps sometime next week. But jury selection is starting on Monday. So what was it like inside of that courtroom? Well, guess what? We know someone who was there. Let's bring him in now. Our friend John DePietro, the creator and host of the show Road Patrol Live, was in the courtroom watching it. And also here for this segment, we have our legal eagle, Franz Borghardt, criminal defense attorney and former prosecutor. So, John, let me start with you. Take us into the courtroom. Some of the things you were observing. What was it like? Kind of set the scene for us, please.
It's tense, Julie. I mean, you can tell that this thing, it's almost go time for next week. Commonwealth is gearing up. But it was, you know, people need to understand, for some of the motions that Hank Brennan, the special prosecutor, is unsuccessful, in many ways he is successful. In the third-party culprit, I don't know whether or not how the Judge Cannone is going to rule. But what he broke out, what he made the defense get up and explain, as we were all sitting there, Julie, it was just preposterous. When we look at these three people, now, first of all, in the past, the defense, Alan Jackson, after the Super Bowl, that big interview, when he was asked who did it, he said, we don't know. Suddenly, they have to defend in court who did it. Let's go through the three of them. Colin Albert. Colin Albert is a teen. To say that he killed a Boston police officer who was his neighbor. And why? Because he plays street hockey. Julie, if we start rounding up all the Massachusetts teens that play street hockey, you know, in the parking lot at Storm Market, they're going to fill the prisons. Colin Albert wasn't even mentioned in closing arguments. Bryan Albert, Brian Higgins, they had attended a funeral that day for a fallen police officer. Bryan Albert served our country in Desert Storm as a Marine, decorated Boston, legendary Boston police officer. I covered him on some other high-profile cases. for the allegations. The emperor had no clothes on. David Yannetti going through the motions that Brian Albert, as his attorney said, it's fiction. He's violent and he's a drunk because he's a police officer and he had a drink that night. Where I think Hank Brennan, Julie, was very effective was, and this is a reminder, no motive, no murder weapon. You don't hear that a lot. 9 witnesses testified. John O'Keefe never entered that house. And a big development that I noticed yesterday, different from the first trial back in the spring, is, as Hank Brennan said, Julie, the federal investigation yielded no wrongdoing. There's no arrests in that. If there was wrongdoing, last year at this time, the third-party culprits seemed to have more gravitas because of the federal investigation. As Hank Brennan pointed out, nothing came out of it.
That's right. John, that's such a great point. If the feds, who are independent from the state investigators, did not find any third-party culprit, not 1, not 2, not 3, what does that say, right? And what bearing does it have on Judge Cannoni's decision now? Franz, in the last trial, I remember she restricted them and said, you can't say anything about it in opening statements. You can try to get there, to get the instruction, see if you can elicit any testimony that substantiates your claim, and they couldn't do it. They never ended up getting that instruction in the end. What do you think the judge is going to do this time, Franz?
I think the judge is again faced with a difficult decision in so much as constitutionally we want the defense to have their right to present a defense, although they have no burden. But she's also faced with a bunch of lawyers looking at a horse saying it's a zebra and there's no stripes. Motive is very thin with the third party defense in this case. So I think she's going to make the same decision. I think it's safer for her to say, well, you know, if you establish it at trial, then maybe you can go into it. But again, it just doesn't. I don't feel like there's enough evidence at this point to point the finger at these 3 and it to be a viable defense. That said, to some degree, the jury makes that decision. So I think she makes the same decision. And I think she is probably very cognizant of protecting the record. I think she's a good judge. I mean, I think she's made some good decisions and she's in a tough spot. So, I mean, I expect consistency.
Yeah, she sure is. She doesn't want this coming back on appeal if Karen Reed is convicted. Speaking of, I think that was some of the logic that went into her other decision yesterday, a big one, where she decided to not let the Commonwealth access the messages between Karen Reed and her attorney, David Yannetti. Franz, I want to start with you on this one, please. We know that the attorney-client privilege is sacrosanct. The prosecution raised an argument that Ms. Reed waived that privilege, as she is the privilege holder in speaking out to the media, but the judge was reluctant to go so far. I wasn't surprised. Were you?
I think that was the right decision. It is a sacrosanct dynamic. We want to have the ability for lawyers to talk to their clients. It creates, and candidly, behind the veil, it creates a huge unnecessary appellate issue.
Right.
If she lets it come in, it creates a huge appellate issue that is unnecessary. Let them try their case. Let the privilege be what it is. Now, if the defense does something to waive the privilege, it might come in. But the only way I see that happening is if she testifies, and I just don't see that happening.
Right, Franz. Great points. John DePietro, let me go back to you. I know that you were watching everything, being eyes and ears in the courtroom for so many of your followers and viewers. And I caught on Twitter, you had said you noticed a moment between Peggy O'Keefe and Hank Brennan. Would you tell us about that?
It was, Julie. You know, Hank Brennan, he's so gifted, and he is now, to me, he's the king of the court. Alan Jackson certainly had the run of the courtroom last time in the first trial. Hank Brennan, I caught, came over, checks in with her. Peg O'Keefe has been through so much. The mother of John O'Keefe not only lost him, but also lost, her daughter. That's why Officer O'Keefe was then raising her, the niece and nephew, the grandchildren. And they just seem that they're on the same page. She seems to have a lot of confidence in Hank Brennan. And Julie, I want to just touch on, the motion about the, client privilege, attorney-client privilege, and also the text. Although he was unsuccessful, he did draw attention to the fact that in Body of Snow, the docuseries, Karen Reed talked about culpability. And although they weren't successful in getting that through, at least it certainly drew the attention to put it out there for the media that one of the first things Karen Read with David Yannetti was discussing culpability. Well, what if I didn't mean to hit him? What if I just ran over his foot? And then she said, I need a couple days to think about it. And then thus, came up with the conspiracy. What I want to stress is this is a very different atmosphere in this courtroom. The O'Keefe family, they were packed. Paul was there. But Hank Brennan seems to really have connected with Peg O'Keefe and the O'Keefe family.
Yes, great points, John. And thank you for that mention, too, about the docuseries, because for anybody wondering, just a point of clarification, is that Hank Brennan can bring in all of her statements. Her statements all are coming on in. That video, I mean, I can't even imagine how many hours that he's got to present to this jury of inconsistent statements Karen Read made. It's just David Yannetti's messages and her private messages to David Yannetti that are going to remain private. Oh, we have to leave it here for now. So many issues with this case. John DePietro, I know we're going to have you back soon. Following you on Twitter in the meantime. By the way, great job with the woman found alive in Rhode Island. You did great reporting on that. Wonderful job.
Amazing.
Thank you for being here this morning. And Franz Borghardt, you're coming with us. Here's what's still ahead on opening statements.
Washington State University. And you're going where? Oh. We're going to be going to Pennsylvania. Oh, okay.
Oh, we got Bryan Kohberger's family members potentially being called as witnesses against him. We're bringing in our criminology expert to talk about how this may tip the scales.
You got 9 months of testimony, right? 4.5 hours, you come back and say, we got a verdict.
Not guilty of the crime of murder.
They're going to blame all this on you.
In this case, the jury was sequestered for 9 months.
Oh, God.
These people were too beat down to even try to fight for their own conviction.
Trial and Error. Why did O.J. win? A Court TV original series. Season finale Sunday night, 8 Eastern and Pacific. Only on Court TV.
Welcome back. Now for what's tipping the scales. We're getting our first indication that Bryan Kohberger's relatives might be testifying at his upcoming trial. The defense team filed a motion asking that his family get priority seating, but prosecutors say that they should not be allowed in the courtroom before they give their testimony. So does this mean that his mom, his dad, and his 2 sisters are on the witness list? Well, you'll recall Kohberger's dad was with him when he was first stopped by police.
He was right up on the back end of that van, pulled you over for tailgating. Is this your car? Okay, cool. Where are you headed?
Well, we're coming from WSU, and we're standing early.
What's WSU?
University, basically.
Kohberger's trial is set to begin in August. He's accused of murdering these 4 beautiful young people, Madison Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin. So, if Kohberger's family is called to testify, how could they tip the scales? And let's also talk about them being in the courtroom. Let's bring in criminologist, professor at St. Thomas University, and author Dr. Debbie Goodman. Okay, Dr. Debbie, let's start, please, with what his family members could potentially offer as witnesses. I have no idea. I would love your thoughts on this. What do you think the state thinks they could possibly get from them?
Thank you, Julie. It's a really delicate matter. Opening statement, by the way, was spot on when you were talking about victimization and the victimization experience that really transcends just the victims themselves. Tragically, as we know, the 4 beautiful lives lost. But as you said, what we call in criminology is primary, secondary, tertiary victimization. So although heinously, sadly, tragically, Maddie, Xana, Ethan, and Kaylee lost their lives, that's the primary victimization. But now to the point in the question of the family, family members are considered the secondary victims, and tertiary would be the rest of us. So, believe it or not, all 5 families, when we include Bryan Kohberger's mother, father, 2 sisters, and then, of course, the parents and the siblings and the extended families of Maddie, Ethan, Zaina, Kaylee, are really experiencing very similar dynamic in terms of guilt and shock and anger and sadness. But what potentially could come when Bryan Kohberger's family members would appear in court? It would likely be conversations about his up, possibly in the teenage years. When was he actually diagnosed with autism? That would be an important revelation, I believe, to set the tone for what the defense is saying. Not so much that the autism led to Bryan Kohberger's decision, as we've discussed, but rather his nonverbal cues. And then it's also alleged, Julie, that Bryan Kohberger participated in heroin use. And if the family members speak to that, that could also be quite revealing. But I would imagine that they're going to use words that are very delicate and sensitive about their own son and their own brother, potentially words like different and unusual. But I can't imagine anything really inflammatory that would come from the parents nor the sisters.
Dr. Debbie, this is such great insight. I could listen to you all day. I want to come to one of your lectures and join your students and hear so much more from you. So, yeah, great points you made about some of the things the family could shed light on that don't have anything to do with the offenses he's accused of, but that paint the larger picture, his upbringing, if he is living with autism, if he did struggle with heroin abuse. These are all great points. And as you know, delicate issues. Could we talk a little more, and thank you for the kind compliment about my opening statement. And I love the explanation you gave us about how these family members, they're secondary victims, as you noted. And by law, you know this, Dr. Debbie, the instant victims, the primary victims, all their families have the right to be there. It's codified. They have a right to be in the courtroom, where Bryan Kohberger's family, there isn't a law in the books that says you're allowed in the courtroom, but just, I think human compassion dictates. Are you surprised that the prosecutor would be digging in to say, stay out of the courtroom until you testify, especially knowing this is a capital case?
Right. Well, I think, again, Julie, it's because of that sensitivity. Remember, we don't know yet the voir dire process and who will be selected, but generally we know that these will be individuals who are husbands, wives, mothers, fathers. And so as much as we want a case to be about the facts and who, what, when, where, why, and how, the delicacy of people's emotions, right? We all get emotional just thinking about the atrocity of these 4 beautiful lives lost, and how could it be? And yet these parents, like we say, all 5 sets of the families here, very much the same emotions and the struggles of the shock and the dismay and the horror, potentially the guilt too, in terms of, yeah.
Right, Dr. Debbie, so well said. If I'm that prosecutor, I would say, look, they aren't witnesses to the crimes I'm tasked with proving. Let me be compassionate and say, go ahead, sit with your loved one. It's not like they could tailor their testimony to something that's really going to influence the facts. These are other issues that may be brought up, as you noted. We got to leave it there for now. Dr. Debbie, we need to let you get off to class. Tell your students that we love having you. Thank you for everything this morning. We'll see you soon. And thanks to you at home. We love having you every weekday morning here on Opening Statements. If you like the show, share it. Go to courttv.com to do that. When we come back, it's time for Court TV Live.